Ready? All right, good morning.
Good morning, Your Honors.
Welcome to an oral argument session here at the Fifth District Court of Appeal. My name is John Harris. I'm joined on the panel this morning by Judges Lambert and Boatwright. Mr. Wells, you having a problem hearing me?
No, sir, I hear you fine.
Very good. Just a couple housekeeping things, 20 minutes per side for the arguments today. Appellant, you can reserve as much time as you'd like, about 20 minutes for your rebuttal. Default is 5 minutes. If you'd like anything other than that, please let me know and we can accommodate that. If you have your cell phones on, please go ahead and silence them. Any other noise-making devices, go ahead and silence them at this time so that we're not interrupted. And just a reminder, the proceedings today are being recorded and live streamed on YouTube. So at this time, counsel for appellant is ready. You may proceed. How much time would you like for rebuttal?
Good morning, Your Honors. I'd like to reserve 5 minutes for rebuttal.
Very good. You may proceed.
Thank you. Good morning again, Your Honors. May it please the court, Robin Hazel here on behalf of the appellant, Dr. Steve Chauncey. The decedent in this case, Addison McNeary, was the companion and life partner of Nell Morgan, Dr. Chauncey's mother. The couple had been together since the 80s, and for that reason, Ms. Morgan was a beneficiary under Mr. McNeary's estate in a 2007 will and in a prior will executed in 1998. The 1998 will is the basis for Dr. Chauncey's petition to reopen the McNeary estate. In 2007, a will was prepared by Mr. McNeary's attorney at the time, Michael Clower. That will named Ms. Morgan as the beneficiary and specifically stated that if she predeceased Mr. McNeary, the remainder of his estate would go to Nell Morgan's heirs, Steve Chauncey. This will was invalidated.
But excuse me, but that will is gone. I mean, he lost that fight. So
Yes,
I look at the case that will doesn't matter. So now we're looking at the 1998 will, which is what he wants to have, what your client wants to have probated. And I guess the concern that I have is I don't think there's a dispute that, you know, the decedent or the testator left it to his brother and then to your client's mother, survivors, and that the brother died first before Miss Morgan, and then Miss Morgan died before the testator. Do you agree with all that?
that is correct, Your Honor.
Doesn't that make his, why is it not lapsed then as the gift or the devise?
Because the 1998 will leaves it to the estate to Miss Morgan and to the testator's brother or the survivors of them. So
Right. So in other words, if Mr. McNeary died and if Miss Morgan was still alive when the testator died, and this 1998 will was the valid will, then Miss Morgan would inherit. She's the survivor. But that, you agree that's not what happened here. The record establishes that.
that is correct, Your Honor. But the language, the survivor of them, the interpretation, that was the trial court's interpretation of the will, but the interpretation of that language, and which is consistent with what later happened in 2007, is that he intended it to pass to the heirs.
But he should have written it that way in the 1998 will. He didn't. I mean, we don't go back and say, okay, we're going to look at an invalid will and decide that Dr. Chauncey is the heir. I mean, how could we do that?
Well, Your Honor, at where we were at the position, the procedural posture of the case is that we were at a motion to dismiss stage.
Right, but and I get that, and let's assume Mr. Gordon committed fraud. Let's just agree with that, and the judge dismissed it. You have to be able to amend the pleading to assert a valid cause of action, and I don't know how you can possibly do that because it's clear that your client's not a lineal heir or a descendant of the testator, so the anti-lapse statute doesn't apply. So common law gifts, bequests can lapse, and so when Miss Morgan died, and the verbiage of the will doesn't say what to do then, it all lapses. I mean, how does that not happen?
Well, because again, Your Honor, that depends, that hinges on the interpretation of the language of the 1998 will.
Well,
and it
but
is not-
that's de novo. I mean, so we're interpreting it. I mean, there's nobody to ask, what did you mean? This is the verbiage. I mean, otherwise we would say every time we'd have a will, we'd have a contest, say, well, I know what he wrote, but that's not what he really meant. I mean, it's clear he leaves it to Miss Morgan or her brother or the survivor of the two. It doesn't say then, like the 2007 will said, if she dies, then I leave it to her heirs. I mean, that's clear that there was a way to have written the 1998 will consistent with the 2007 will, so that it's clear that Miss Morgan heir, apparently your client's the only heir, would then take under the testator's will, but he didn't have that in 1998. I mean, it's clear on the document.
The 1998 will was not written as artfully as the 2007 will was written. So the language is not as clear in the 1998 will, but again.
But it is clear. No, I mean, I'm sorry, but it is clear. It's concise. It says, I leave it to these two people or their survivor. It doesn't then say, and oh, by the way, if by chance they both die before me, then this is what I want to have happen. And when it doesn't say that, you want to read in something, or your argument, I guess, today that we're talking about is that we read into something that, well, he said that later, so that's got to be what he meant in 1998. And I don't know how one does that on the plain face of the 98 will.
And again, Your Honor, I go back to where procedure, we were at a motion to dismiss. We didn't even have the opportunity to develop any of that, to develop those arguments. We were at a motion to dismiss.
Well, okay, development now. I mean, I'm not trying to be curt about it. I don't understand. The judge may have gotten the wrong rationale, whatever her rationale was, but she dismissed it without leave to amend. She dismissed it with prejudice. So the issue before us is, okay, can you amend the complaint to assert a valid? I mean, basically, is your client has no standing. I mean,
right, and that's
right, and so you can allege as many horrible things that Mr. Gordon did, and I'll give you that. Let's say he committed absolute fraud. I knew about this will and I didn't have it. Didn't want to tell anybody about it because that would hurt my being able to inherit. But you still have to get past the fact that if the 98 will is the one that's probated, that your client somehow takes under it, and I don't see how he possibly can.
And again, Your Honor, that goes back to a matter of interpretation, and we should be allowed to.
Well, I'm going to interpret it when we're done today. So you need to explain why I'm interpreting it wrong. So, I mean, I don't know what else to tell you.
Because, Your Honor, the language that says the survivor of them, I understand Your Honor's interpretation is meaning the survivor of the two people named in the will. Our position is it's the survivor of those people named in the will, meaning their heirs. So
do you have any case law or anything that backs that up? Because typically, as Judge Lambert said, usually the survivor of them means survivor of the two individuals. It doesn't mean their children. I mean, most of the treatises say that. So do you have any case law that supports that proposition that survivor of them would then leave it to their children? Because again, usually what the courts have said is that survivor of them means the survivor of one of the two individuals. It doesn't go to their children at that point.
Right. I don't have any case law, Your Honor, and we'd be happy to brief that issue for the court if we were allowed to do so, because that's not an issue that was, the court mentioned that in its ruling in passing, because the primary.
But I thought that's exactly what the court said. The court said there's cases out there that say that the survivor of them doesn't mean their children. It means the survivor of the two individuals. I thought that's exactly what she said when she concluded the hearing. Was that not what she said?
That's what she said at the end of the hearing. She said she had cases before her that interpreted this language, but the court never identified any cases identifying it the way the court interpreted it. And I have not found any cases because but I could brief the issue if the court would like us to brief the issue. But the way the plain language is written, it says the survivor of them in equal shares. The equal shares language in the 1998 will qualifies the names of the people and the survivor of them. If that will meant in the alternative, meaning Nell Morgan, if she predeceased John McNary, she would get everything, then the in equal shares portion of that has no meaning. So that's why our interpretation of the language in the will was that it was in equal shares to the survivors of the persons named in the will. Because of that language, that qualifier on equal shares. Between two people, there could be no equal shares because it's only two people. If one survived the other, they would get everything. But if you're, again, if the court would allow us to, we would be happy to brief the issue further. But that was what we were asking the court to give us an opportunity to present evidence on this. Again, we were at the motion to dismiss stage of the case.
What evidence would you present?
Well, we would have opportunities to develop one of the evidence, one of the pieces of evidence, again, goes back to what this testator's intent was. This 2018 will was done 2 months before the decedent.
Not the 2008.
That doesn't matter. I mean, the 2018 will is a red herring at this point.
I would respectfully disagree, Your Honor, because the timing of it and the fact that it changed this testator's entire estate plan that had been in place for decades. And this 2018 will changes all of that. And we're here because at every turn, Mr. Gordon has successfully, unfortunately, blocked Mr. Chauncey's ability to even have standing to challenge that will. So I do submit that it is.
Well, he hasn't blocked his standing. I mean, your client wanted to have the 2007 will probated. They had a trial about it. He could have won if the judge found that the will was validly executed. He would have, you know, then you would have then gone ahead and he would have standing to fight the 2018 will. But once he lost on the 2007 will, then he really doesn't have standing, as I think Judge Boatwright's pointing out, who used to be a probate judge, as I used to be a probate judge. He's saying, well, the 2018 will, your client has no, he doesn't inherit if that will's not valid. I know he thinks it's invalid because of the circumstances, and I get all that, and I get that he's frustrated about this, but it still goes back to, all right, if that 2018 will is thrown out, then who takes under the testator's estate? And it would have, the only way your client would then take would be under the 1998 will, which I think at least two of us are voicing to you extreme concern that your suggested interpretation of the will, it's on its face. It's not a matter of it says what it says. It's a matter of a legal interpretation of that document, which is de novo. It's not a matter of what does the trial judge believe or not. I mean, at common law, bequests can lapse.
Yes,
and the anti-lapse statute was enacted to ameliorate that, but it ameliorates it to allow lineal descendants of the grandparent of the testator to take. So when, in other words, if your client was the heir of this fellow, Mr. McNary, then I wouldn't be asking you these questions. I say, well, okay, you're right. You do have a right to pursue this. But that seems to be the problem. And it seems like that's what the judge was saying, the trial judge was, or the probate judge was saying at the end of that hearing, which certainly is what we've talked about here leading up to this. And it would seem like that would be something that you'd want to talk to us about, not say we need no more briefing.
Yeah, and Your Honor, that's the point that I made when I was answering Judge Boatwright's question. Our position of the interpretation of the 1998 will is based on that qualifying language about the survivor taking in equal parts. Again,
and I think what Judge Boatwright is suggesting, and I'm suggesting, that's what we've particularly looked at here, and none of us can find anything that supports what you're saying.
Okay.
Let me ask you this, Ms. Hazel. Would you agree that if our interpretation of that language from the 98 will is consistent with what the trial judge did, that your client would not have standing in this case?
If your interpretation is as Judge Lambert says, then the gift would have lapsed. But in this case,
if your client does not have standing, then is there error in dismissing this with prejudice without leave to amend?
If there's the case law, Your Honor, is clear that if there is no way to amend, then yes, the court can dismiss with prejudice. But we submit that there was a way to amend because looking at the language of the 98 will, especially that qualifying language about taking in equal shares, could not be referring to the only contemplating the two people named, because if it meant to be in the alternative one will inherit if the other one dies, then there would be no need to split that in equal shares. And the equal shares language qualifies not just the named beneficiaries, but the survivor language. And because of that qualifier, it's our position that the testator meant to include the heirs of those people named in the will. And
Well, even if that's true, that it's to be in equal shares, and you say that you have Miss Morgan's share there, then to Judge Lambert's point, does your client then fall under the anti-lapse statute?
I would argue that he does. Our client is Miss Morgan's sole heir. So anything that would have passed to her estate would have standing to challenge the 1998, the 2018 will, I'm sorry. And because her estate would have standing, Dr. Chauncey, as the sole heir of her estate, would have standing to challenge. And so that's why our position is the court, again, at the stage that we were in the proceeding, and because there was a way to amend the complaint based on the language and that qualifying language about taking in equal shares.
But I mean, it wasn't really your request to amend saying, I want to add more stuff to show how fraudulent Mr. Gordon was. This is kind of, I don't know what term we want to use today. This really wasn't the intent of why you wanted to amend. You weren't saying, oh, by the way, I can explain. I mean, it's a legal, you plead facts. You don't plead legal, here's my interpretation of the law in pleadings.
And to that point, Your Honor, because this does come down to an interpretation, we should have been allowed to get past at least the motion to dismiss stage to make these arguments to the court. The court cut us off and didn't give us any alternative to make these arguments. And so that's our position, that's why we argue the trial court erred. There were enough facts alleged in the petition, and as Your Honor notes, there was no dispute. And regarding the 2007 will, even though that will was invalidated, it was at the malpractice trial for the attorney who prepared that will that Mr. Gordon testified under oath that he was aware of the will. He was aware of prior wills. He was also aware of the 2007 will in that testimony. And so it is our position that because there is no factual dispute that he had knowledge, we should have been allowed to move forward and present further evidence that there was fraud and to give Dr. Chauncey standing to challenge the 2018 will. And I see
Ms. Hazel, you're into your rebuttal time. You can keep going if you'd like, or you can reserve what's left.
I'll reserve what's left, Your Honor.
Very good. Thank you. Mr. Wells, you may proceed, sir.
May it please the court. Good morning, Your Honors. The thing I'd like to start with is that when Mr. McNary made his last will, it was because his friend had already died. Nalgene died and his brother had died, and he wasn't going to do another will leaving his deceased friend anything.
But that's not really the issue here today. I mean, that's a factual dispute. Miss Hazel's client may dispute that. I mean, it's a legal pleading about whether your client committed fraud, but I think maybe it should be pretty clear from the discussions during the appellant's argument that that's not the issue as we see it at all. In fact, I think I said, let's assume your guy committed the most fraud ever in the history of jurisprudence in Florida. Miss Hazel's client still has to be able to take under the 1998 will, and that's been the real concern that we've had based upon the verbiage of that will and the circumstances as to who died when.
We're also talking about a copy. No one's found or knows where the original is.
But we're at the pleading stage, so we assume these things are true and that this will be could be a probated document. And so the question is, the trial court err in dismissing the case with prejudice without leave to amend? Clearly, if Dr. Chauncey would take under the will, then it would be error to dismiss it outright without leave to amend, because it wouldn't be futile if he had standing. And that seems to be the legal issue here. If he has no standing, then it's no different than some guy on Beach Street out here trying to contest the 2018 will. Dr. Chauncey has to be able to win. There has to be a reason for us to set it aside that down the road he could win and inherit under the testator's intent of how he wanted things distributed of his estate. right?
Right.
Okay. So do you have anything, I mean, I think Judge Boatwright and Judge Harris perhaps, when maybe we're asking your opposing counsel, do you have any cases that suggest that Ms. Hazel's interpretation of how this would pass under the 1998 will is accurate, or that the case law has suggested otherwise?
My understanding is that Chauncey is not a devotee of that will, and the two devotees are both dead, and there was no follow-up on that basis in that document, which also has one page with one date and another page with another date on it. So it's either a composite of two separate wills put together, or it's one will with one group on it, witnessing it, saying one date and another date. So it's got
That's a factual issue. I mean, we're at pleading, so whether it looks odd in one fashion or another, we accept the allegations of Ms. Hazel's client as true, saying this is the will, it's a valid will, I should take under that will. Mr. Gordon should have told everybody about it. He fraudulently did that because he didn't want to lose his bequest under the 2018 will. I mean, I know you guys all cite to Dean, or you both talk about the Dean case. I was actually the trial judge in that case, or the probate judge, and it's the opposite scenario that we have here. What happened in the Dean case was there was a later will that was unhelpful to Mr. Dean's client, who happened to be a lawyer, and he didn't disclose that to me, I guess. And so that's why I set it aside. This is the opposite, the scenario of the chronology. But that being said, I don't think Dean is dispositive here either. But I know you both talked about it.
Mr. McNary, do you believe that the appellant takes under this 98 will, this 1998 will?
Mr. McNary, I'm sorry, I'm Wells, Your Honor.
Right. Do you believe that the appellant in this case,
No, I think you're right.
take under the 1998 will? Then why not?
Because he's not a beneficiary of that will, and there has to be a living beneficiary when Mr. McNary dies. That has to be the will in play, which it wasn't. And if it was, if he died with just that will, neither of those beneficiaries survived him. And I don't, Mr. Chauncey wasn't named in the will. And my client has no duty to notify devotees of prior wills, if you believe the Clubman case. And he isn't a devotee under a prior will. He's related to a devotee under a prior will. So he's one step further removed from not getting any notification from anybody for anything. We had no duty to tell Chauncey anything. And the law, I can find no decisional law that says we're responsible to inform Chauncey of a copy of a will that was revoked and not live when Mr. McNary died. And my opponent counsel says, well, he changed his will. Sure he did, because the person he was going to leave it to predeceased him. So he changed his entire estate. As I understand the law, we have no obligation to notify Chauncey of a prior copy of a will that doesn't even name him. And we didn't know about it at the time. My client didn't find out about this copy of this will till after he was no longer the PR, and the lawyer that drew it, Clower, found the will in his desk drawer, but my client, the PR, was already discharged. So they come in with, we've committed fraud for not telling Chauncey about a prior copy of a will. Now,
well, but I mean, that again, that's a factual thing. Let's just, they're alleging that your client knew that. And so they would have to prove that, but that's not the issue for the trial judge or the probate judge at the time of the initial motion to dismiss hearing. I mean, they would present evidence that suggests that, the testator was not competent when he executed the 2018 will. Your client knew he wasn't competent. Your client was aware of the 1998 will. Your client was aware that Dr. Chauncey was going to inherit. So that's why he got this 2018. I mean, I know you can shake your head and say, no, they won't prove it. I get all that. And the trial judge may listen to all that and not buy any of it. And that's what trials are about. But that's not what we're here about today. That's not what Miss Hazel is arguing about. But what we're discussing is, okay, he still has to be able to take under the will. It doesn't, he shouldn't, it doesn't matter to, if he doesn't ever inherit under these documents, then it doesn't matter what Mr. Gordon did in a legal technical sense. Isn't that this case?
Well, he sure wouldn't inherit under a copy.
Okay, well, I guess I won't beat the dead horse here. I don't know. I mean, copies can be probated. I mean, you know that. We as a probate judges know that can happen. You just telling us way before there's any evidence, that doesn't carry the day much. But to me, that's not the day carrying discussion we're talking about today. Don't keep telling me your guy's a good guy and they would never win anyways. That's not what we're talking about on this appeal. That's down for the trial if you ever have a trial.
I believe that the trial judge did the correct thing in that she saw Chauncey had nowhere to go. He had no case when he got there, and he had no way to improve it into a situation that was going to fly. And she could see that. And I believe she was eminently correct in saying to them, you don't have it now, and I don't think you can plead your way there. There's nowhere to go to get there.
Well, he could plead it. I mean, that's where you and I are going to, I guess I don't want to waste the next 11 minutes of your time. He could plead it if he inherited it under the 1998 will. Whether he could prove it is the issue that you're kind of, conflating here in our discussions. If he could prove it, that your client knew all that and then did this alleged devious behavior and convinced Mr. McNary when he was 98 and not competent to sign a will and 4 or 5 weeks before he passed, then that would certainly be something that is talked about in will revocation trials on a regular basis. I know that. I sat through them. But that's not what we're here about now. It's more of a legal, does the Dr. Chauncey have standing? He doesn't get to amend because there's nothing he can amend to show that he has standing. If he does, then he should get to amend. Period. That seems to be what the case is about.
I don't think he does have standing to amend, Your Honor.
Okay.
The arguments I would have made today are that we had no duty to tell prior devisees about this will if the Clavin case is still good law, which I believe it is. I have no reason to think it isn't. And that, again, Chauncey was not the devisee of any will. He was a relative of a devisee, of a copy of a will, the original, which has never been found.
But
now,
if the 1998 will said, I leave it to the survivors, and if neither of them survive me, I leave it to their heirs in equal share, then he would have standing.
But it
right?
didn't say that. But it didn't say that. It just said, I leave it to those two people or the survivor of them, and they're both deceased. And word to
Right.
say.
I know that. And that's the problem that Miss Hazel has to overcome.
Yes, sir, I think so.
Or scenario, whether it's problem, I don't know that's the right term.
I don't think there's much more I can offer other than the things you don't want to hear about, which are all the reasons why my man didn't know about this will, because he'd never seen the original will.
Well, let's just be real clear. I don't want to cut you off. If you want to talk about things that we have made clear that are probably not pertinent to the decision here, and our evidentiary matters, not pleading matters, which I keep telling you.
Yes, sir.
That is a thing to talk to the trial judge about in trial. That I swear I'm Mr. Gordon. I don't know what they're talking about. I never heard anything about that. And if the judge says, he didn't commit any fraud there, Dr. Chauncey, you lose. That's down the road if you ever have a trial. That's not why we're here. Miss Hazel says she wants to be able to have that ability to present that. That's why we're here. And whether she should be able to have that ability, because whether her client has standing or not is the threshold thing. We hear that all the time in foreclosure litigation. It's just as equally valid in other litigation.
Well, I don't want to talk about things you don't want to hear about. So I think that the correct assumption or agreement is that Chauncey did not have standing and he can't plead his way to standing. And I think that the probate judge who had a lot of experience saw that and knew that and said, you know, you have nowhere to go. And so there is that case that says that if she makes that, she had leave to amend a complaint may be denied where the amendment would be futile. And I think she felt that it would be futile. So.
Well, let me say one more thing, just as a guy, since we are live stream, you talk to us about anything you want to talk about. I'm saying I don't know how it's relevant. I'm not saying I won't listen to anything. You're not telling me how it becomes pertinent to what we have to decide, but I don't want down the road somebody saying that Lambert's cutting everybody off from saying their piece. So you say whatever you think you need to say to us as a panel and to me about what you think this case is about.
Well, one thing that it's about is the alleging that Mr. Gordon committed fraud by not telling Chauncey about a copy of a will, the original, which he had never seen. And I don't think there were enough facts there to constitute fraud to set aside the fact that he was discharged as a PR. So I don't think they met that burden. That's basic, that and the fact that I think the judge was correct in her assumption that he didn't have a case when he got there and wasn't going to be able to reform his way into one when he left there. So that's basically the essence of my argument, Your Honor. And I'm not here to bore you or offend you. I don't want to go into areas.
I'm not bored. I'm not offended. I prefer you stop saying those gratuitous things that certainly don't make me look like a neutral, impartial judge. I'm listening. I'm telling you what I think is the issue. I'm telling you where I think that what you're talking about isn't directed to the issue, but you have 5:55 left. You say whatever you need to. I've told you what I think is important in my decision, and you can direct and tailor your argument as you see fit.
I think there's no point in me arguing further at the moment.
All right, thank you, Mr. Wells. Ms. Hazel, you have just over 3.5 minutes remaining. You may proceed.
Just going back to the fact that we are, again, as the court pointed out, this is the pleading stage. So we were, we asserted enough facts in the petition to allow this case to proceed. Now, what we were dealing here with the language, going back to the language of the 1998 will that was a concern for Your Honors, I again would point out the language that talks about awarding to the two parties or the survivor of them in equal shares. Our position is that portion of the 1998 will is ambiguous enough that we should have been allowed to proceed to further develop it. We should not have
Well,
been
this is
denied the right.
a fill in the blank form will, right, for 2 or more beneficiaries. So that's why
Yes.
that language is arguably there, right? Because this could be for 7 beneficiaries.
Yeah, yes, Your Honor. It is a fill in the blank form, and that is another point, Your Honor, that again we should not assume that it violated because it was a fill in the blank form. It wasn't as artfully written as one that a lawyer would have typed out, but we should not assume that it violated any lapse laws or that it that this language is clear and unambiguous, because we submitted is not clear and unambiguous, especially because of the testator's clear intent in a subsequent will. And if we were allowed to further develop the facts, we don't know. And again, we weren't allowed to present any other witnesses who were around at the time of the 1998 will that could have spoken to the testators, what the testator wanted. But we certainly have evidence of what the testator's intent was in subsequent wills. It was always his intent not only to provide for Miss Morgan, but to also provide for her heirs. And because the language, again, is in the 98 will is ambiguous, we should have been allowed to amend the complaint, the petition if necessary, but we argue we didn't even need to amend. We alleged enough facts that it should have gone forward, and then we should have been allowed to develop those facts, and then the judge make a decision based on what we presented. And so it is our position that the trial court erred in first dismissing the petition, which alleged sufficient facts to move past the pleading stage. But even if the court found that there weren't sufficient facts in the pleading, then we should have been allowed to amend it to assert certain arguments, for example, the ones presented here today regarding the ambiguity of the language of the 1998 will. So, Your Honor, for those reasons, we do submit that the trial court again erred, and this court should reverse and remand this case with instructions to allow us to move past the pleading stage and to present evidence to the court, and then the court can make a decision based on the evidence presented.
Okay, thank you both very much for your arguments this morning. Court stands in recess.